8 of the city and county. We have 36 speakers signed up. The lights will be on. Mr. Hook, did you get it on? The 36 speakers are now taking up part of their 30 minutes.
We had to listen to this shit for 4 hours.
The first speaker speaking on this bill will be Councilman Nolan, who is the author and has worked with this bill. And then we will start with your 30 minutes. Jim Nolan, Councilman Nolan.
Mr. President, I would just like to simply give an introductory remark to those who are here tonight relative to this bill. First of all, as most of you people are well aware of, the state legislature changed some portions of the criminal code, in fact, I think the entire criminal code, in 1971. And because of that change, there have been many, many problems that have developed in the courts simply because of the fact that the criminal ordinances of the city and county of Denver are in conflict with the state statutes. There was a committee appointed by the mayor, which basically consisted of members of the Bar Association and some of the law enforcement agencies to review these entire ordinances and suggest changes to them.
Managed to flare up against homosexuality. It refers to the scriptures, to Leviticus and St. Paul. The book of Leviticus also condemns wearing a scarlet dress and eating shrimp. St. Paul has managed to stand as the patron of all anti-drag legislators, since he told women that since their hair was so beautiful they had to cover it. So much for St. Paul and the book. I'm sorry, well,
I know you want to get it all in, but if you speak a little slow, I think it would be a little easier for us to understand.
okay, I was told, we've only got so much time.
Yeah, back off the mic.
Golly, our one chance maybe for liberation. In considering the long and bloody record of the Judeo-Christian tradition, I don't think we should bother with it. For insight, at least in this manner, we should look to the totality of human history, which shows quite clearly that homosexuality can flourish in cultures which are reaching their height, which are which are in their prime, as well as cultures which are in their degeneration and decline, as in the decline and fall of the Nixon administration, as well as other empires. Now then, decadence is a word which is much in the air today. In fact, I believe in a private conversation, some of the members of the City Council have used this word with regard to gay people. Decadence, I think, is a word that belongs only to the vocabulary of the ruling class. In these days, obviously, the ruling class is the bourgeois, and it is this word, I feel, a bourgeois alarmist cry used whenever the traditional morality, a morality which is based on the possession of women by men, this morality is challenged. And this morality is challenged, for instance, in the 1920s and now again in our own day. It was challenged in the 20s when there was a great moral upheaval. Women won the right to vote. America was urbanized, and the farm boy morality did not fit in the big city. Denver is a big city. Now, it is true, we are decadent. We are part of a regenerating process. We are affirming new moralities. We are experimenting with the very fabric of life itself. And we are all butterflies, I guess, in a certain way. And if you continue to legislate against us, as you have done in the past, all you are going to do is give to us greater conviction and greater firmness to oppose every one of these tactics, not only here in the City Council, not only by applause and demonstrations, which are our legal right as citizens, but also in the courtrooms and finally in the polls when it comes up for the vote. Thank you very much.
Thank you. Kathy Bowen. Bondman, I guess it is.
Gentlemen, my name is Kathy Bonham, and I am a practicing attorney here in Denver. Yes, I'm a practicing attorney here in Denver. My office is at 1452 Pennsylvania Street. I primarily deal with criminal law in my practice, and I am vitally interested because of that in the proposed criminal laws that you have before you tonight. First of all, I believe that you have all been presented with a copy of a proposed ordinance by the Gay Coalition. I hope you have. If not, I'm sure you will be, which directs itself to 841.1 in the proposed code, specifically as to public indecency. I would like to just speak to you on a very practical level. I would ask you to read that proposed ordinance. I suggest to you that it is constitutional, that it is a good substitution for what you now have before you, that the disorderly conduct part of the proposed code is unconstitutional, that it is a violation of the Fifth Amendment under the Constitution of the United States. It is vague, it is overbroad, it is a violation of equal protection, and in some cases it's a violation of First Amendment freedom of speech. The ordinance that you have before you on lewd, lascivious, and wanton behavior is very similar to the one that we now have in the Denver Municipal Code. It is being challenged, and eventually it's going to fall. I'm not concerned about the question of preemption. Perhaps it is or it is not preempted by the state law, but it is unconstitutional. And I suggest to you, just on a very practical level, that you consider the proposed ordinance, and I would suggest that that be substituted for the ordinance that you now have, that it will stand a constitutional attack. I would also suggest to you that the ordinances that you have before you are replete with unconstitutionalities. And I would also make one suggestion. You are concerned with the spending of taxpayers' money and concerned with clogging up the courts with unnecessary litigation. Well, if the ordinances that you have before you are passed the way they are, then you're going to have a tremendous amount of litigation as far as the constitutionality of these ordinances are concerned. I suggest to you that's a waste of your time, a waste of the court's time, a waste of the taxpayers' money. And this can be resolved very simply if some time is taken. I suggest to you that in the city of Denver, there are a number of attorneys who are, in fact, constitutional law experts. Now, perhaps the city attorney's office has constitutional law experts, perhaps the Bar Association does too. But I suggest to you that there are many who are experts. Some of them are here tonight who may or may not have a chance to address you. If you would take the time to consult with some of these people whose names could be made available to you, who are reputable members of the Denver community and of the Bar Association, that they can point out to you the areas in these ordinances which are in fact unconstitutional. And I say in fact because case law, United States Supreme Court case law, federal court case law, and even in some instances Colorado Supreme Court law will show you that they are unconstitutional. And when they are challenged and finally do reach a higher court, they're going to fall. And then you're going to be in a position of trying to deal with that, either because a lower court has held them unconstitutional, as in the case which you have been presented with approximately 8 months ago, one of these ordinances, what to do when one judge says it's unconstitutional and then it has to go up to a higher court. And all of this can be handled now if you would just take the time to consult some other people who can show you the cases, who can show you the law, and show you where these things are unconstitutional. They're vague, overbroad, and violation of equal protection. And I would ask you to do that just to save everybody a lot of time. And I would also suggest, and this is just a suggestion, but we're dealing tonight with a very large segment of criminal laws that affect everybody in the city and county of Denver. And I would ask you if you would consider devoting a session to public hearings on just these proposed criminal ordinances so that they could be discussed in a detailed way instead of in such a hasty manner, to provide you with information that perhaps you don't have time to gather on your own, and could be quite enlightening. Because after all, these are the laws, the criminal laws that affect everyone in the city and county of Denver. It's not something to be lightly taken. And I would just have one other suggestion, and now I'm only appealing to you on, again, a practical level. A lot of these ordinances do allow the police in Denver a great deal of discretion, and a lot of the time that's spent in enforcing some of these laws, especially relating to morals, sex, prostitution, all of the things that we've been discussing tonight, engage a tremendous amount of time, effort, energy, and money on the part of the citizens of this city and county, insofar as the way that the officers use their time in, quote, enforcing the law, when in fact we do have a lot of crime in Denver, a lot of hardcore crime, burglaries and assaults and robberies and murders, things that people are legitimately concerned about. And my suggestion is that a lot of the energy which is now being directed into this area of vice and morals could much better and much more effectively be spent in other areas of law enforcement where it's vitally needed. Thank you.
Thank you. Janet Louise Sergei? Sergei? S-E-R-G-I, pass. Daniel Brenham?
Mr. President and members of council, I'm speaking both as an attorney and as a representative of the Socialist Party of Colorado. We feel that the proposed legislation, or any proposed legislation like it, which seeks to regulate private consensual sexual activity or makes possible, even possible, police harassment, is not only unconstitutional but very unwise and classist and sexist in nature. I think one point that hasn't even been brought up tonight is the whole problem, not only of the fact that police are given a wide range of discretion in enforcing an ordinance that contains vague and overbroad language, but we always have with us the whole problem of perjured police testimony and the fact that police officers always seem to be interested in picking up the little guy and not picking on the big person. Our interest in opposing the proposed ordinance is twofold, basically. First of all, we believe, as do many people committed to constitutional government, that the state has absolutely no business poking its nose into the private affairs of its citizens. Secondly, we feel that proposed legislation is blatantly anti-working class in nature. What we're planning to do is to have the police department harass and disturb and bother ordinary working people, take them off the streets and parks of Denver while allowing criminal, housing, and health problems to go ignored. For this reason, we urge the council to defeat both proposed ordinances 822 and 841. Thank you.
Thank you. Mamie Misrick? Oh.
Yeah, Mr. President, are we going to wait till the end to ask questions?
That's why you have a list, so you can make a note if you want to ask. Go ahead.
My name is Maureen Marizek.
Thank you.
I'm not a legal expert or anything like that, but I'm speaking as a citizen, and I feel that it's when a government starts trying to legislate morality, which is what I feel is what this code is doing, as far as telling people that certain acts are illegal, certain personal acts are illegal. I feel, plus the fact that what I have seen in the past with the city ordinances, they've been unequally enforced, and I think that's my biggest fear, is that these laws are going to be passed and they're going to be inflicted on a small segment of the Denver of the people in this community, and I don't feel that we need a law to just apply to one segment of the community. The same thing, I have some doubts about the prostitution code. I feel that the people who are prosecuted for prostitution are the prostitutes, not the pimps or the customers or anybody else involved, and I have a lot of serious doubts about that. I feel like if you're gonna pass a law, it should apply to all the people. We find that right now with Nixon in the White House. Nixon at this point feels he is above the law. I think he might change his mind, but you can't. It goes from the top down, and you can't start, with a law that applies to people of Denver and say, this applies to this community, and that's, we have to enforce it because that's what, we think the rest of the community wants this. Well, the rest of the community isn't here demanding it tonight. And I think that should be a mandate to this council to re-examine these laws and how they're going to be applied to the community. That's all I have to say.
Thank you. Ethel Matthews.
For the purpose of disturbing someone or harassing someone. And you might want to take that same approach. That's up to you, gentlemen.
All right, any further questions? Bill?
Mr. President, I might point out that the one possibility that occurred to me when this was brought up earlier today by Mr. Roberts was that the question may be sufficiently covered by the, this after all is under a multitude of sins labeled disorderly conduct. Now on page 19, you will see subsection 841.1-2, parent 1, which refers to the use of profane, obscene, or offensive language directed at someone, which tends to an immediate breach of the peace, and also by parent 3, which wherein a person that disturbs or tends to disturb the peace of others by violent, etc., conduct, or by loud or unusual noises. And it occurred to me that that may be sufficient, and that we could get along without parent 7 entirely. That's just one possibility for that I thought I'd raise.
Mr. Stoffel, what's your reaction to that?
That would be a council's decision is which way they want to go. Of course, there is activity that could take place on the streets that would not be specifically directed at an individual, which also could be such that the council might want to control. But this would be up to the council's, would be the council's decision.
Well, Mr. Stoffel, as you well know, when the committee made these deliberations on all of these, we were most concerned about the input from the various agencies that were involved. And I think we would be most concerned as to how this would affect the conduct in the city and county of Denver. Are you saying that if, as Mr. Bradley indicated, that subparagraph or subparent 1 and subparent 3 does not cover anything that would be covered, or possibly something that would be covered under 7?
Well, number 7 is broader than 1 or 3 and covers areas that 1 and 3 do not cover.
Can you tell us of some instances that you might be aware of that have been prosecuted under 7 that could not have been covered by 1 and 3, or 1 and 3, right?
This would be the situation of somebody who was walking down the street using this language and not directing it at a specific individual and not screaming it out, but just walking down the street where it would be overheard by other people and where in effect disturbing these people. The others would not be directly applicable, because the one is the language would be directed specifically at an individual and tend to an immediate breach of the peace, and the other deals with a case where there's a loud type activity which was disturbing the peace rather than a specific language or actions causing the disturbance.
Could I ask you, Mr. Stoford, Paren
Yes.
1 says directed at or in the presence of. So that Paren 1 covers both conditions, it would seem to me.
Well, Mr. President, maybe with this is something that we should study further by the committee.
Mr. President,
Mr.
I just wonder if we couldn't get back to the public hearing type of operation and then keep some, and get to some of the technical questions possibly a little later on this.
Well, the only thing I would point out is that I felt that one of the primary problems we have is with this section, and that we could eliminate some of the need to go through so many hours of hearing. We can hear it. I'm willing to sit here and go through it. But if we know what some of the problems are, and we can thrash at them and see if we can reach some conclusion, then we can have the hearing. But maybe it could reduce some of the volume.
Mr. President, two comments, if I may. As I understand it, Mr. Bradley, did you not tell me that the City Attorney's Office and the committee by the bar, Mr. Keller, have made recommended changes to this bill already that we aren't aware of tonight?
Yes.
I was wondering if it'd be advisable before the public hearing starts, to let us know what those recommended changes are.
If I might, Mr. Nolan, Mr. President, refer to Mr. Stoffel.
Fine.
He has the laundry list here.
Okay.
If that's the way we wish to proceed, I would first refer to page 4. The definition of gambling. Which we would suggest that possibly the use of the state definition, which we did not use initially, would be more inclusive. The definition of gambling in the state statute was pointed out would cover situations where there was not a specific game involved, like somebody going down the street wanting to take a bet on whether it's going to rain tomorrow or not. And it would cover this type of situation where, in the definition that we picked up from the city ordinances, it covers only games.
So you got a new definition for us there?
Yes.
Okay.
It's in 40-10-102, parent 2 of the state statute, state criminal code. I would, in going through, I'll also point out matters which I'm not sure whether the council may or may not be familiar with. On page 10 in the section on intoxication and drug addiction, House Bill 1279, which will be CRS 664516, as of July 1st of next year, under the influence of alcohol, has been will have been preempted by the state, and there will be no criminal charges. It will be treated as a medical problem.
Well, Mr. Stoff, is it your desire to leave this as it is until next July? Is that-
I would think that that would be, because there would be no procedure to handle it between between January 1st and July, that we would need probably need to leave it in here, but it's something that the council should be aware of. On page 11, in section .1-1, parent 9, after the word perform, I would suggest that
To open discussion. Any interruptions or misconduct, the people will be removed by officers that are in the room. So if you want to be heard, and you want a fair hearing, and you want everyone to talk, then you better limit your remarks. And repeating statement after statement, I will use my best judgment if I feel a speaker is saying something the speaker before said, and make that remark and ask them to limit their speaking. All right, this first speaker is Mr. Richard Griffith. If he would come forward and state his address and affiliation.
Mr. Cook, my name is Richard Griffin, and I passed Mr. Cordell.
Excuse me, could you hold the microphone up?
My name is Richard Griffin, and I passed Mr. Cordell Boyce, who will speak for the Gay Coalition.
Thank you. One other thing I want to mention to members of council, if they will refrain from asking questions until after the public hearing. They each have a list of the speakers, and they can make notes of any speaker they want to ask a question of. All right, Mr. Paul Hunter. I beg your pardon? No, Mr. Hunter is signed up next. Mr. Boyce, if he's on the list here, will have his turn.
Excuse me,
If he isn't on the list, then...
he is on the list.
Okay, then when we get to him, we'll hear from him, okay?
Okay, then...
All right, Mr. Paul Hunter. Oh, you want to continue then?
I will continue. Mr. Cook, I had a smart little speech written talking about being a human being and a citizen and a queer. But I am so filled with disgust at you, at the council, as my first personal contact with the system, that I don't think I can give it. You know, I find it very hard to love my country if I can't even respect my city council. I think everybody here, apart from the technicalities and the data, knows what all of these people are here for, what the problems with the bill are, the problems with the police, the city government are. I think being gay and facing those problems makes me a much bigger man than you being straight and running away from. Thank you.
As I mentioned before, you're using up your time in these demonstrations. Now, if you want to hear these people, then let's hear them. Otherwise, we'll clear the room of everyone that is not listed on this sheet. Mr. Paul Hunter.
Mr. Cook, members of the council, I'm Paul Hunter. I'm an attorney. I live at 611 Harrison Street. In general, my comments, my feelings are, after having reviewed this bill extensively, with regard to several specific points. Number one, with regard to the points raised by Councilman Roberts, as to Section 841 1-2 paren 7, I am unfamiliar with any Colorado cases which define lewd, lascivious, and so on. I would submit to the council that if the presumption is that the police officers will be able to either read cases or interpret the law, then that's an abrogation of your function. Your function is to legislate and to define what shall be prohibited in Denver. With regard to the discussion of the duplicity with state statutes, a large number of these provisions are taken verbatim from the existing state law. I fail to see that that clears up any possible misunderstanding. If that is the case, why not have a Denver divorce law and a Denver murder law? I don't see that by adopting verbatim existing state statutes into the municipal code that you've solved any problem. With regard to one of the councilman's questions as to specific examples where 841.1-2(7) would apply when the others wouldn't, I think that the presence of most of the people here is testimony to the fact, the common knowledge, that this section, which is drawn from 824.1-2 in the existing ordinances, is one of 3 charges which are commonly filed in vice cases, both female prostitution and in male homosexual cases. So as to specifics, what situations would this cover that the others wouldn't? I think that's clear. That's what the areas that it would cover, that the ones which basically go to public order do not apply to. In general, I would submit to the council that there are a number of areas in this bill which make it, in effect, a bad bill. For instance, the provisions of promoting obscenity to a minor say anyone who promotes any material. It doesn't say obscene material. Does this include tobacco? Does this include drugs? Does this include pornography? Unlike the obscenity ordinance, there's no definition of what the material is. Offenses by minors, I would suggest that certainly the Children's Code applies to offenses by minors and that the City Council enactments would carry no weight. Mr. Stoffel mentioned the public intoxication. That's been decriminalized. With regard to religion and vandalism of Christmas displays, I don't know that those ought to be singled out. In summary, I would say that the American Bar Association at its recent convention in August in Washington passed a proposal both by the House of Delegates as well as the General Convention encouraging legislatures to stay out of the area of enacting laws which regulate sexual or private conduct between individuals. One of the sponsors of that resolution quoted from John Stuart Mill, who said that the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. I seriously question whether the thrust or effect of this proposed bill will be in any way to enhance the quality of life in this city or for us as citizens. I think it's a bad bill. I think that your further consideration is demanded, and I would urge that you reject the bill as proposed.
Thank you, Mr. Hunter. Elizabeth Matthews. I beg your pardon? All right, thank you. Fred Zook. Oh, I thought you said you were passing.
Well, I was just
I'm sorry.
in favor of someone who told me to speak.
Oh, go ahead.
I just say, as a feminist, that I am against any bill which punishes people for transcending sexual barriers, as this bill, this particular section against lewd, wanton, and agreeing, what is it? Yeah, offering to perform an act of public indecency. The word offering enables vice squads to arrest males who are merely out searching for other males for courtship purposes. This is, in effect, punishing homosexuals. The same way society punishes females who transcend their sexual boundaries in their careers or in any other way. And therefore, as a feminist, I reject it. I think it's unconstitutional and it is very unfair.
Thank you. Fred Zook.
Gentlemen, I'm Fred Zook, 2380 Jasmine. The criminal code, to me, implies that it would talk about crimes such as unwilling destruction or harm to other people. I would like to see us move in the direction of limiting our criminal definition to that, but specifically to this code. I think the discussion we had previously about some of the definitions or some of the words that are used that are imprecise, specifically in sections 802 and 822, some of the words like lewd and offer or agree to offer, some of these kinds of things. I think an intelligent and responsible approach to this kind of language would be to define it more precisely for a couple reasons: to keep unconstitutionality cases out of court so that our court time isn't tied up with this kind of problem, and as was stated before, to aid the police so that they are aware of what is and what is not a criminal activity. And this in turn would remove as many possible sources of entrapment as possible. So I would like to see you come back with a more responsible proposal. Thank you.
Thank you. Terry Magnuson? No, that ain't Magnum?
Mr. President, members of the council, ladies and gentlemen, brothers and sisters, I think the issue has been dodged tonight. I think everyone on the council knows what's going on. I have been dealing with the council for 9 months. I was promised 9 months ago, the Gay Coalition was promised 9 months ago by Perry and by the members of the Police, Fire, and Excise Committee that we would have a chance to speak to that committee, that we would have a chance to bring to that committee the grievances of the gay community of the city. Councilman Cook, I believe you were there, and I believe if you have newspaper clippings from the Rocky Mountain News, the promise was repeated in the Rocky Mountain News at that time. I think the issue is the City Council has failed to accept its responsibilities to the gay community. I think the issue is that you people are sitting here and you don't want to talk about it. You don't want to deal with it. You don't want to face it. You would rather not have to realize that we are the people that elected you. We are the people that you meet on the street. We are the citizens of Denver. This ordinance which you propose is nothing but an attempt on the part of the city and county's legal persons to try and clean up the ordinances which are even now being attacked by a lawsuit in the district court. This attempt is being made to try and maintain the old statutes, but to put them in cleaner language. Now, I think everyone here knows that. And you people who refuse to define these words, to refuse to define what is lewd, you come to us and say, well, I am quite confident that the police department is capable of making these decisions. I am quite confident that the police department has access to the city attorney and this sort of thing. Well, I would like to read to you some statements about what happens, how the police department enforces these things. Now, I do not expect that you will believe what I say. I do not expect that you would believe what a member of the Gay Coalition says, what a gay person stands up and says he's being persecuted. So I have taken the liberty to bring to you some statements which were written not by me, not by anyone in the Gay Coalition, not by anyone gay as far as I know, but written by the Vice Squad officers themselves. These notes come to you through the courtesy of the City and County of Denver, the officers' notes. In one case, I will not read the name of the defendant because obviously these criminal types should not be bandied about. However, in the event that you do not believe what I am saying, I will give you the case number, and any of you can go downstairs tomorrow and find what I have said. In the matter of case number 3-3412, this is a direct quote from the officer's notes. Schletter received complaint from a park employee. Salzman engaged in a conversation and asked, "Are you looking for a guy?" Salzman replied, "Yes." Defendant said, "He was not in the mood for sex." Salzman asked defendant, "What put him in the mood for sex?" Defendant says, "I like to give blowjobs," and was then arrested. Now, if a police officer goes up to you and says, are you looking for a guy? And the police officer says, yes. That seems to me to go beyond the bounds of propriety in these matters. However, defendant engaged in the matter of case number 3-23529. Defendant engaged in a conversation with vice officers for 15 minutes and then offered oral sex. Now, these people are not running up to the police officers and saying, Would you care to go under the bush and commit a lewd act with me? These people, these police officers are enticing these people, spending 15 minutes to try and get them to commit themselves. If you people on the city council consider this to be a lewd act, then I and all of us here are guilty of lewd acts. But I challenge how many of you have not been guilty of sitting in a bar and talking to a young lady for 15 minutes, hoping to get her to go with you somewhere. I have one final comment which I wish to read. Officer Pearson, Davies, and Salzman were conducting a routine homosexual surveillance at the state capitol grounds. Officer Salzman, were working undercover, came into contact with the above suspect. Oh, by the way, this is case number 55292 in the Denver County Court, the people versus the defendant. The suspect and Salzman were engaged in a normal conversation. Salzman was asked if he was from Denver. Suspect was asked the same question. Salzman was asked what he was doing out at night. Salzman stated he was looking for a little action, but it was dead tonight. Suspect agreed. More casual conversation. Suspect then said, "Do you have a car?" Salzman replied in the affirmative. Salzman stated that he had a motel room. Suspect asked, "What do you like?" Salzman asked suspect what he had in mind. Suspect said sex. Salzman asked the suspect what he, suspect, liked to do. Suspect then said, "I like to give blowjobs." Okay, now if you want to tell me that if a policeman puts himself up in the Capitol grounds, says he has a car, says he has a motel room, says it's rather dull, says he's looking for action, and someone says, "If you have a car and if you have a motel room, let's get in that car and go to that motel room," if that, sir, is lewd, then I fail to see what you are doing, if not the fact that you are reinstating the sodomy laws, which the state abolished some time ago. It seems to me, gentlemen, that unless you define these things in this ordinance, that the police are going to continue to respond in the same way that the police have responded in the past. If you abrogate your responsibility, then this is one thing. If you, gentlemen, wish to make it illegal for one man to contact another man and ask him if he would care to go to some private place and commit a sex act, then I suggest we have nothing further to discuss. I suggest that we should not be talking about it here. We must take our case elsewhere, to the people, to the polls, to the press. I think that the state has spoken to the point of sodomy, to this point of gay love, to the point of two men or two women doing whatever they please.
Could you sum up, please?
I certainly will.
15 minutes has gone by.
The state legislature has spoken to the fact that it is not illegal for two men or two women to have private sexual acts. How then can it be otherwise? I think that this 15 minutes that we have been allotted is a mockery and a shame.
It was a half an hour.
Half an hour, I beg your pardon.
We've used 15 of it almost, 10.
Very well, thank you very much.
John Bloom. John Bloom? Is he next on the list? No, he isn't. When he comes up, okay. Gerald Gerash?
Gentlemen, you have seen me before. I have spoken to you individually and as a group. I'm not unfamiliar to you. As you know, I am from the Gay Coalition. I'm a lawyer in Denver, and I primarily practice criminal law. The time limitation which you set out, to wit 30 minutes, reminds me of what is going on in Washington, D.C. today. You recall the Watergate case. At first you may not see the similarity, but I will point it out to you. The basis of the Watergate case was a contempt of the people's right to vote. People in power in this country manipulated the basic freedom of every citizen of this country, and that is to vote. That was clandestine. It was hidden. And finally, it was uncovered. Your decision to give us 30 minutes to speak on criminal laws which affect our lives and everyone's lives in Denver is not clandestine contempt, but open contempt. I basically have 2 points, and I want to get to my speech that I have prepared. And that is that what this bill does, it says that private conversations are illegal in the city and county of Denver. And private conversations in particular that have sexual connotations are illegal. And secondly, I wish to make the point that the only force in this city that wants to make these private conversations illegal is the Vice Bureau of the Denver Police Department. And I will show you some slides, some obscene slides. Unfortunately, they will not violate your ordinance on obscenity.
You're not going to show them here.
Well, they will not violate the law on obscenity.
I'm the President of Council. They will not be shown.
I have some other slides, and they are statistics.
There will be no slides of any sort.
You have the zoning slides, Mr. President. May I present my case?
We're not voting on any bill. Now, do you want to proceed with your speech, or do you want to take up all this time?
And these slides will be shown.
They will not.
All right. Now, our position, the Gay Coalition position, is, in fact, public sexual acts should be the subject of crime. They should be prohibited.
Let me put it this way, on your slides, any councilman that wants to stay afterwards and watch them and go through them with you is privileged to do so. So go ahead.
Mr. Chairman, hey, I'm sorry, honestly, but I think if they have something that is part of a case, they should be shown, regardless.
As long as everyone here understands the time limitations, then, if you feel that you want to go ahead, go ahead.
Well, the only thing is I think there's some, responsible people who do want to make their arguments. All I would ask is, ask council.
Show the slides.
All right.
Show the slides.
Just to reassure you, I use that word obscene in jest, and they are, in fact, statistics derived from the county court.
I'm deferring to Mr. Hook, who is a member of council, and he requested they be shown, so
all right.
It is under his request that they're being shown.
Now, as a lawyer, I've had the opportunity to defend approximately 50 gay men in the city and county of Denver over the past couple of years. And these arrests were based on conversations only, no acts. And there was a pattern. I went through all my files. There was never a citizen of this city that made a complaint. The only complaint was that of a Vice Bureau officer. There was a pattern of arrest which Mr. Mangan outlined, which I corroborate. The Vice Bureau is in plain clothes. He poses as a gay person. He makes a statement, gee, I've been to a gay bar, names the gay bar, and no action, what's doing, and so forth. And the conversation, as Mr. Mangan quoted from the police officer, occurs, and the defendant is, in fact, arrested. Now, those were my impressions as a lawyer handling about 50 cases. I wanted to make it scientific. With the help of some people and Mr. Paul Myers, who's a mathematician and a statistician, we went to the case files and looked at every arrest under 823 for the first 3 months of 1973. Now, I'd like to present that slide at this point, and Mr. Myers will be available for your questions if you have any about other aspects of the survey. Now, on the left, if you look down at the bottom, it says conversation only, and that refers to just that these were arrests under 823 and involved conversation only. Where it says gay, it goes up to 100% and all others 0. That is, every single person arrested, and this confirms my going through my files, was in fact gay. And the next statistic on the right, at the bottom, is the key word, complaining witness. In all these cases, 99.1% of the complaining witnesses were Vice Bureau people, and 0.9% were citizens of the city. Now, what are the conclusions there to the ordinary person is obvious, and that is that the citizens of this city are not complaining about these private conversations. It is only the Vice Bureau that is complaining about them. Those are the conclusions. Now, I call upon you. These are startling statistics. I don't know if you think they are, but I think they are. I would ask you, if I were a black person and came to you and told you that 100% of the arrests for burglary were of black people only. And not only that, but there were no citizen complaints, but just cops were complaining. Now, wouldn't your sense of justice be moved just a little bit? If I were a Chicano and I told you and brought you statistics that for aggravated robbery, only Chicanos were arrested and the only complaining witness were cops, wouldn't that move you somewhat? Therefore, gentlemen, what I call for now is not a consideration of the bill, but that you defer the bill, but that you proceed to investigate the tactics and policies and psychology and perversions, if you will, of the Denver Vice Bureau. That, to me, seems the issue and the conclusion that is demanded of these statistics. Now, regarding the two bills, the ordinances, the public indecency and the disorderly conduct, there will be other speakers here, lawyers, who will be addressing themselves to the constitutional issues. And any one of you who is a self-respecting lawyer, who knows anything about the Constitution, will agree with their arguments that the laws that you propose are flagrantly unconstitutional on many grounds. I will not address all the points. This state has mandated to you and has told you, in effect, that you cannot pass the ordinances that you are proposing. The state has, in the CRS Criminal Code, after 40-3-401, they made it very clear. They stated as follows, quote, "Voluntary participation in deviant sexual acts is not made a crime," unquote. Now, you mean to tell me that conversations about a perfectly legal act can be made a crime? You can go ahead and do it if you like. Our lawsuit, which is pending in district court, will be accordingly amended to include your new proposal.
Could you please sum up so we can hear some other speakers?
All right. In effect, the people of Colorado, the citizens of the city, have stated what the law is, and that is that private conversations including private conversations involving sexual connotations, are not the concern of the criminal law. The police in this city should be responding not to their own perversions, as is indicated on the chart, and their own aggressions and hang-ups, but they should be responding to citizens' complaints. Women in this city cannot walk freely at night because of the fear of rape. These are the types of complaints that the police department should be responding to, and they are complaints. There are complaints of burglaries, aggravated robbery, assaults, and beatings and knifings. It's a total waste of the taxpayers' money to have Vice Bureau people hunting out gay people who are only seeking other gay people for an evening of conversation and compassion and understanding, for which every citizen of this country certainly has an inalienable right to. Nothing further.
All right. Dolores Levine. Dolores Levine. Oh, I'm sorry. It looks like a B here.
Mr. President, just a matter of procedure, if you don't mind, I might suggest that if we could get a couple of people in the front row to vacate their seats and stand in the back, and as you call the names, if you were to call two names, the one to come to the rostrum and the next one to follow.
Well, they're doing fine.
We'll save
We're getting
some of the
along
time.
great. Go ahead.
Thank you.
Mr. President and members of the council, Dolores Leone, 1454 Elm. I'm a psychiatric nurse. I've been in psychiatry for about 10 years. I'm coming to speak to you as a citizen, but also as a mental health professional. I recently had the occasion to read the city ordinances, both the old code and the new revised code, and I was really very appalled. I was very, very happy that someone put it in my hands. I was appalled for a number of reasons. I agree with Councilman Roberts and the previous speaker, Mr. Hunter, that much of the language is still very vague and does not lead to clear and unbiased interpretation. We don't leave that kind of interpretation to the vice squad in the street. We do that here. Secondly, that which is a little clearer in the code makes many of us criminals, I'm afraid to say. Much of the things that are described in there could be used in response to any one of us and our own behavior. Number three, I have trouble comprehending why we spend our tax dollars to employ law officers to seek out, for harassment's sake, certain offenders under this present code. It's a very nasty business, and I would not like to invite a vice officer into my bedroom. Lastly, we all know, and I believe council knows too, that these laws in this case are not applied and enforced equally. These ordinances are often used as a means of harassment and entrapment of a small, powerless minority of second-class citizens, the gays. This shrieks of discrimination to me. As a mental health professional, I'm concerned about the myths we live by and the things we use to judge other people by. The gay needs concern and understanding and instead gets rejection and condemnation from family, from friends, from the church, and now we work to make him a criminal. We force him into a life of guilt and low self-esteem, and we force him to seek out mental health assistance. I think for your own information, you ought to know that there's a trend in the mental health field now to remove homosexuality from the APA, American Psychiatric Association manual. There's a trend to no longer look at homosexuality as either deviant or sick behavior. Unfortunately, we still have some mental health professionals who are often much more judgmental than they are therapeutic. I beg you to look at this bill again. I think we have made errors in the past in our code, and I think we mock justice if we turn our back on a chance for an enlightened revision of the code.
Thank you. A.C. Glenna, G-L-E-N-N. I have A.C. I hope that's correct.
Your Honor, all I have to say is, for the gay people, every time one of us dress out in the street, like I am now, we always get racinating. Now, I don't see what's wrong with wearing a hat that looks like a woman, or a shirt, or a coat. Now, that don't make no sense whatsoever, as long as we ain't got no bra. Excuse me. As long as we ain't got no bra on, or wearing a girdle or stockings, or even trying to look like a female. But I dress as I please. Nobody don't buy my clothes for me. I buy my own. And that's all I have to say.
Thank you. The Reverend Alex Lukens.
The Reverend Mr. Lukens found it necessary to leave and asked that I speak on his behalf and my own.
And what is your name, sir?
I'm the Reverend Paul Murphy.
Okay, are you on the list?
No.
Elsewhere? Okay.
I'm the Reverend Paul Murphy, a United Methodist clergyman, and I wish to speak not about the legal matters or even theological matters, but simply to make 2 points very quickly and very briefly. First, that I think we all need to recognize that God-given human sexuality has long been an issue that we've had a great deal of difficulty in our society, especially understanding, appreciating, being able to talk about and discuss in an open and healthy way.